addresses implementation of the 2021 State v. Blake decision, which held that the strict liability crime of simple possession of a controlled substance is unconstitutional, and as a result, all persons convicted of the offense are entitled to have their convictions vacated. Substitute House Bill 1492 establishes standard requirements and procedures for vacating convictions, resentencing, and refunding legal financial obligations and other costs pursuant to the Blake ruling. It sets forth the qualifying convictions that are eligible for vacation, and it provides that legal financial obligations, readily ascertainable collection costs, and document verified collateral costs are subject to reimbursement for all persons who have a qualifying conviction or who paid these costs pursuant to a qualifying non-conviction. The Administrative Office of the Courts must work with clerks to develop a comprehensive reports for each court of all qualifying convictions and qualifying non-convictions. And based on these reports, the prosecutor must file an ex parte motion with the applicable court to vacate each qualifying conviction and for a refund of LFOs and other costs for qualifying convictions and non-convictions. Notice to the defendant is not required, and the court must determine these motions without requiring the presence of the parties or counsel. These motions must be filed, completed by January 1st, 2026. Specific procedures are established where a person may be entitled to resentencing as a result of a vacated conviction. And regardless of whether a prosecutor is expected to file a motion, a person may themselves apply to the court for a vacation of a conviction or refund of LFOs and other costs associated with the conviction or non-conviction. When a conviction is vacated, the clerk must notify the Department of Licensing to reinstate the person's driver's license if it was suspended, and must also send notice of the vacation to the Washington State Patrol, who has 7 working days to update its criminal history records. The bill establishes standards for determining LFO amounts and other amounts that are eligible to be refunded. A person may bring a motion to challenge the amount of any refund within 3 years after the refund is issued. A person who is indigent may request publicly funded counsel to assist with this motion if there's funding provided for that specific purpose to the Office of Public Defense or the Office of Civil Legal Aid. LFOs ordered refunded must not be reallocated to any other LFOs that the person is required to pay. The Administrative Office of the Courts must administer a refund bureau to provide direct refunds to persons entitled to a refund, including direct refunds of costs of supervision that are paid or have been paid to the Department of Corrections. And the Department of Corrections must provide the AOC with a certified list of qualifying convictions where costs of supervision were paid. This list must be provided by January 1st, 2024. Lastly, the Administrative Office of the Courts must provide notice to persons of their right to and process for obtaining a refund, and must establish a searchable online database where a person can determine whether or not they've had a conviction vacated or whether they're entitled to a refund. And I will conclude there and turn it over to Yvonne.
Thank you.
Again, for the record, I'm Yvonne Walker, staff to this committee. There is not a fiscal note available on the substitute version of the bill yet. However, as Edie mentioned, first, the bill requires the Administrative Office of the Courts to develop reports of all persons with qualifying convictions or qualifying non-convictions. The Administrative of the Courts must then provide a copy of those reports to the court clerks, the Office of Public Defense, and the Office of Civil Legal Aid. The cost for the Administrative Office of the Courts to work with the clerks and all of the Superior District and Municipal Courts in order to develop those reports and distribute them is estimated at $18 million per biennium. This funding includes funding for 10 staff to maintain their legal financial obligation refund bureau, as well as funding for court administrators and clerks to process the orders. The Office of Civil Legal Aid assumes that they will need to review, process, and forward those reports to contracted legal aid providers, as well as make referrals for individuals seeking legal assistance. Due to the additional workload, OCLA estimates that they will need a total of $225,000 in the 23-25 biennium and $243,000 in the subsequent biennia to fund a Blake LFO relief administrative position to handle those reports. Additionally, the bill requires court clerks to transmit the court orders to vacate a qualifying conviction to the Washington State Patrol. The State Patrol has 7 days to update the records and reflect the vacation and transmit the vacation order to the FBI. As a result, the State Patrol requests a total of $2.9 million in the 23-25 biennium and $2.4 million each biennium thereafter to fund 12 additional staff as well as IT costs. Lastly, the Attorney General costs associated with providing legal services to the Administrative Office of the Court relating to implementation of the new requirements of the bill, the creation and maintenance of a refund bureau and a searchable database, as well as other reporting requirements, totals $55,000 during the 23-25 biennium and $30,000 each biennium thereafter. And that concludes my remarks.
Thank you both. Any questions for Ms. Adams or Ms. Walker? Thank you. We'll now go to public testimony. Oh, no, actually, I would like to, if the prime sponsor, Representative Simmons, you threw me off by not being in your seat.
Thank you, Mr. Chair. Yeah, I wanted to come up here because it's so hard to testify with my back to all of you. And I guess for the record, I'm Tarra Simmons from the 23rd Legislative District. I'm happy to offer this work to you. It's been a very long interim working on this with so many players. And just to give you an overview, in February of 2021, as we all know, the Blake decision came down. And what that means is that everybody who's been convicted of a possession of controlled substance previously is entitled to a vacate of that conviction and a refund of their legal financial obligations, and the state must do this. And in the last 2 years, about 43,000 cases have been taken care of, and there's an estimated 262,000 cases. So we still have a lot of work to do, despite best efforts in the last 2 years. Currently, right now, 39 counties are doing it in different ways. Some, and the cities haven't even really started their work. And the relief, it varies widely across different jurisdictions. Some prosecutors will refund all of the LFOs, some won't. Some will include language that prevents deportation, some won't. Some counties reallocate the money to other cause numbers, some don't. And so what this is creating is no uniformity across the state, and it depends on which jurisdiction you're in to what relief you'll get. We have one example of in Cowlitz County, and I do this work in my day job, and so that's why I know so much about it. But in Cowlitz County, the prosecutor had said in one of our clients' cases that the clerk would calculate the amount that the person was going to get back, but then the clerk got the order from the judge with no amount in it and said that the LFO amount needed to actually be in the order. So what this means now is that in Cowlitz County, the clerk's going to have to go back, and all of those are going to have to be redone. And so this bill is about trying to create some efficiency by creating a statewide process for the courts to handle all of this backlog of the vacates and the LFOs. Without intervention this year, because the AOC Refund Bureau is going to start in July, which this legislature already funded and created. And actually, this bill came out of an AOC Refund Bureau collaborative task force that I was a part of over the interim with multiple stakeholders. And they're asking for this bill because they need direction on how to handle the refunds that are no longer are the county clerks going to be issuing these refunds. It's going to be the AOC Refund Bureau. And they need clear direction. And so if we don't intervene at this juncture in this session, they're going to start that work in July, and they might not be doing it right with clear rules as these cases continue to be litigated in the courts. And so I'm really trying to solve a problem for efficiency and save us money down the road and having to redo everything. Let's see. So I just want to flag, we've spent at least 100 hours working on this with the Superior Court judges, the District Court judges, the clerks, the Office of Public Defense, the Office of Civil Legal Aid, court administrators in AOC and WAPA, and the prosecutors still have concerns because this bill is taking away some of their discretion. But I think it's important to take away their discretion and create uniformity, unfortunately. And also, I wanted to make sure that you know that, again, the legislature has already given a lot of money towards this problem, so we'll have to analyze the fiscal notes as they come in. And that's it. Thanks.
Thank you, Representative Simmons. Are there any questions for our prime sponsor? Not seeing any questions. Thank you, Representative Simmons. And we'll go to public testimony on 1492. Representative Gregerson.
Thank you, Mr. Chair. Let's go ahead and bring forward Juliana Rowe and Russell Brown, Roland Thompson for in person in the Zoom room. Let's go ahead and do Ali Homan, Corey Gulmet, Lindsay Huer, and Josie Delvin. And when you're ready, Juliana.
Good afternoon, Ormsby, members of the committee. My name is Juliana Rowe, and I'm here on behalf of the Washington State Association of Counties. And we are signed in opposed to the bill. I think, as Rep. Simmons said, in response to the Blake decision, the state has given a lot of money, or provided a lot of money, and a somewhat of a system to address the Blake decision. And as she said, counties have processed about 43,000 cases of vacations, which is a huge step. However, this bill expands the scope of what the Blake decision is. It expands who can be resentenced and vacated, and it expands the definition of legal and financial obligations. So for counties, this means that we would have to go back and take another look at those 43,000 cases, in addition to the remaining 250 to 300,000 cases that are estimated to be included in that overall number. So we would like the state to provide funding for those additional cases if you pass this bill forward. Thank you.
Thank you. Rep. Gregerson.
Thank you. Russell?
Good afternoon, Chair Ormsby, members of the committee. My name is Russell Brown, Executive Director for the Washington Association of Prosecuting Attorneys. I'm here testifying with concerns on House Bill 1492. As noted, at the end of 2022, about 43,000 vacates have been completed. We have concerns with this bill because it does expand the work of prosecutors and clerks. The current process is ongoing. This bill adds particular types of cases. It extends it beyond what courts have already required. It adds things like non-conviction cases. Nelson v. Colorado, a Supreme Court case, only includes particular cases that had resulted in convictions. I also want to highlight that this bill also includes something that protects reports in Section 11 that are publicly available in other areas and then become available at AOC, which concern us because those are likely reports the counties will have to try to defend, which will subject us to additional litigation. And the last point I would highlight, as Rep. Simmons indicated, one provision of this bill prohibits prosecutors from refiling particular cases, which we think does limit a constitutional duty of a prosecutor to evaluate and have the ability to file those cases. Thank you.
Mr. Brown. Mr. Thompson.
Mr. Chairman, members of the committee, my name is Roland Thompson. I'm here representing the Allied Daily Newspapers of Washington, the Washington Newspaper Publishers, and the Washington State Association of Broadcasters. And we have no opinion on the underlying bill, but we have concerns with Section 10, 11, 12, and 14, which are the public disclosure sections of the bill. They're actually the creation of the reports and the public disclosure closure there. It's confusing because these reports are going to be compiled from publicly available documents in their entirety, and then for a period of time they will be, I guess, under this not disclosable, and then they will become disclosable again when they are held in the searchable database and in the reports that I suppose the counties hold. But it's confusing to us when we read through this, and if it leads to confusion, it will probably lead to litigation when people try to access this information. And so we would ask that the committee take a look at those costs that would be associated with potential litigation in this area. Thank you.
Thank you, Mr. Thompson. Representative Gregerson.
Thank you. Let's go ahead and we'll bring Gracie O'Connor up to testify in person after we go to the remote. And we'll start with Allie.
Good afternoon. Can everybody hear me? Just want to make sure. Okay, I saw some heads go. Good afternoon, Chair Ormsby and members of the committee. My name is Allie Holman. I'm the Director of Legal Services at Washington Defender Association, and I'm testifying on behalf of WDA and the Washington Association of Criminal Defense Lawyers, and we are strongly in support of this bill. Without this bill, we're going to have chaos. As Rep. Simmons said, we have watched 39 counties try to struggle with Blake, and we're talking about constitutionally void conviction. So this money is going to be owed, and how we do it, we want to have the best efficiency that we can. And this is what this bill provides a streamlined, efficient process based on the lessons we've learned in the last 2 years with Blake. With that, this will help reduce justice by geography and make sure that if you are in Ponderay County to Waikiakum or King County, that you have the same chance of making Blake the reality that it should be. And I appreciate the committee's time with this. And so I will yield back because I know you've had a very long afternoon, everyone. Thank you.
Thank you so much. Rep. Gregerson?
Thank you. So we have Corey.
Yes, thank you. Good afternoon, Chair Ormsby, members of the committee. My name is Corey Guillemette, testifying on behalf of Civil Survival, which operates one of the 2 Blake legal service programs in the state of Washington. And I'm here to voice my strong support for HB 1492. Currently, Civil Survival is flooded with Blake requests, so much so that we've had to stop accepting new cases altogether. Without this legislation, the state would need to provide millions of dollars in additional funding to civil legal aid each year for the next decade just to meet current demand. By streamlining the process, this bill will allow the vast majority of people to obtain full relief without an attorney. And it will allow us to focus on the small number of cases where an attorney is truly necessary. We will be able to meet demand with existing funding, and we will only need state funding for the next several years instead of increased funding for the next decade if we do nothing. We encourage you to vote in favor of HB 1492's streamlined and efficient process for clearing the Blake backlog. Thank you.
Thank you. Rep. Gregerson?
Lindsay.
Good afternoon, Chair and members of the committee. I'm Lindsay Hewer with the Association of Washington Cities, here today in opposition to House Bill 1492. While there are a number of positive policy pieces within the bill, overall it would add unnecessary burden to local governments. The fiscal note finds that the only impact to cities will be in law enforcement reporting requirements, but this fails to capture the significant fiscal impact to Washington's 100 municipal courts. Municipal courts will face the similar cost drivers as counties, including clerks, prosecutorial, indigent defense costs. One other specific point, we're concerned about the fiscal impact of requiring clerks to do an objectively reasonable search and to make substantial efforts to obtain the collection agency records, as this language is ambiguous and has the potential to create unintended liability. We ask that this be changed to simply requiring that a search be conducted. We sincerely appreciate the legislature's funding of $21.5 million last year to offset the costs, and we request that you, rather than imposing the new burdens in House Bill 1492, instead continue the state funding so that the work at the local government can continue. Thank you so much.
Thank you. Josie.
Good afternoon, committee members. For the record, Josie Delvin, I'm the Benton County Clerk testifying on behalf of the Washington State Association of County Clerks. We have worked extensively with the stakeholders and the representative on this bill. And while we have made some progress, we are still concerned about some areas. In particular, the fiscal note for us, we were very conservative in our estimate of 15 minutes per case for clerks processing this. This bill expands on the cases, sometimes going back to cases that we have already processed, and would impact our work on that. So for us, over the 8 years, which we think it would take us 8 to 10 years to process 50 years worth of refunds, would be $42 million for clerks offices alone because of the impact on our staffing. And we are concerned about what I am seeing here in Benton County, the new hearings that are being required. We have 7 cases pending where there are hearings to argue cases that have already been dismissed and already refunded. We have refunded $2.6 million in the past 2 years, and we think that has been quite an extensive effort. And we are also concerned about the reporting being confidential, and we think that that would lead to litigation for clerks' offices. So we would like to continue to work on this bill in the areas that we have of concern, in addition to the fiscal notes that we think will impact the state budget. So thank you for your time.
Thank you, Ms. Delvin. Rep. Gregerson?
Thank you. So before we go to Gracie, let's go ahead and bring over Philip Nab in the remote section. And Gracie, when you're ready.
Thank you, Chair Ormsby, Ranking Member, and members. I'm Grace O'Connor, Managing Attorney for the Blake Defense Program at the State Office of Public Defense, testifying in favor of Substitute House Bill 1492. 1492 injects certainty into the delivery of Blake relief, which will allow us all to get through the work faster and much more predictably, allow us all to make better use of state dollars, and to more easily project need in the future. OPD submitted a decision package asking the legislature to continue funding OPD's Blake work into the next biennium, namely funding our triage team and our aid to counties for Blake defense work, which is principally focused on resentencing and vacates of old convictions. We can achieve OPD's requirements under 1492 with the funding requested in our earlier decision package, so the bill would not require additional funds for us to implement. This is because while the bill expands the boundaries of Blake relief in some ways, it also removes the need for defense attorneys at every step of the process and repurposes the defense role in other ways. OPD will be updating its fiscal note to reflect this discussion, and we urge you to support this bill. Thank you.
Thank you.
Thank you. Let's go to Lori on remote.
Thank you. Can you hear me?
Yes.
Thanks, Chair Ormsby and committee. My name is Laurie Lane, and I'm from Buckley, Washington. I have real concerns about 1492 and the Blake, the State v. Blake decision that caused this whole thing in the first place. I have I'm definitely against this. I see real disaster with drug-related crimes increasing because of this. I really am not for it. Thank you for your time.
Thank you, Ms. Lane. Rep. Gregerson?
Thank you. Philip, when you're ready.
Good afternoon, Chair Ormsby, members of the committee. My name is Philippe Nab. I am the Reentry Program Manager for the Office of Civil Legal Aid, and I'm here to speak in support of Substitute Bill 1492, which provides relief for individuals affected by State v. Blake. I would like to particularly highlight what we see as the effective use of civil legal aid in this bill. Okla's been tasked by this bill to provide civil legal services to individuals seeking to appeal or augment a determination made by the court and clerks. Okla believes we can provide these legal services at the FY appropriated funding level, which we would have asked to be continued for the FY 24-25 operating budget. This structure will allow Okla to provide targeted legal services to individuals who would most benefit from legal services. This would fundamentally change the delivery model for individuals by providing a more targeted approach for civil legal services that would both expand the number of Blake-affected individuals who will have their harm redressed and ultimately save the taxpayer money. Thank you very much for your time.
Thank you, Mr. Knapp. That concludes the public testimony and the public hearing on Substitute House Bill